Today, we're discussing a critical topic for all healthcare professionals, the legal framework for emergency medical care in India. Whether you work in a government hospital or a private clinic, understanding your legal obligations can protect both your patients and your practice. Let's dive in. Let's start with the foundation. Article 21 of the Indian Constitution guarantees the right to life, which the courts have interpreted to include the right to emergency medical care. This right applies to both public and private healthcare facilities, making it your duty as a healthcare provider to prioritize life-saving care over any procedural formalities like payments or legal documentation. Here are the laws you must know. 1. The Clinical Establishments Act, 2010. It mandates that all clinical establishments provide emergency treatment to stabilize patients. Failure to comply can result in fines or even suspension of your registration. 2. Indian Medical Council Regulations, 2002. Section 2.1 clearly states that providing emergency care is your humanitarian duty. Non-compliance can lead to temporary or permanent cancellation of your medical license. 3. Motor Vehicles Act, 1988. Section 134 protects doctors from legal liability when providing emergency care to road accident victims in good faith. Indian courts have reinforced the obligation to provide emergency care through landmark judgments. Parmanand Katara versus Union of India, 1989. The Supreme Court ruled that saving lives takes precedence over all procedural formalities. P.T. Parmanand Katara versus Union of India and Ors, 1996. This extended the obligation to private hospitals and doctors. Paschim Banga Ket Mazdoor Samiti versus State of West Bengal, 1996. The court emphasized that failure to provide emergency care is a violation of Article 21. High courts have further solidified these principles. In Pravat Kumar Mukherjee versus Ruby General Hospital, which was in 2005, the Calcutta High Court ruled that hospitals refusing emergency treatment could face liability for damages. Similarly, in Rajesh Kumar versus State of Uttar Pradesh in 2019, the Allahabad High Court mandated emergency care regardless of a patient's ability to pay. Failing to provide emergency care can lead to severe consequences. 1. Criminal prosecution, under IPC Section 304A, causing death by negligence. Under IPC Section 336, endangering life. 2. Professional consequences, suspension or cancellation of your medical license. 3. Civil liability. Hospitals and doctors can face compensation claims for damages. Now, here's some good news. Under Good Samaritan laws, healthcare providers are protected from liability when they offer emergency care in good faith and follow standard protocols. Remember to maintain detailed documentation, including the interventions provided, reasons for transfer, and time-stamped records. Here are some recent updates you should be aware of. 1. Telemedicine guidelines, expanded for emergency consultations. 2. Enhanced penalties, under the Clinical Establishments Act for violations. 3. Mandatory emergency protocols for all healthcare facilities to ensure compliance. If you found this video helpful, please like, share, and subscribe to Dr. Lawyer Official for more medico-legal updates.